Good morning. I'm Anno Saxenian. I'm Dean of the School of Information at UC Berkeley, and I'm really pleased to welcome you here and congratulate you for finding this beautiful auditorium. It's a lovely space, but I walked around the entire building before I found the entrance. I'm really pleased that we have a setting like this to discuss what is really one of the most important issues of our era, something that has a lot of important consequences for information and for access to information throughout our lifetimes and that of future generations. A bit of background that you may already know, so I'll be brief. 5 years ago, Google introduced a service called Google Print at the 2004 Frankfurt Book Fair. The service, quite revolutionary, allowed you to search the full text of books that Google had scanned, converted to text using optical character recognition, and stored in its digital database. Most of us, I think, have used this. Many of it use it daily. It's now better known by its new name, Google Book Search. I think it was an exceedingly ambitious, some would call it an audacious vision. Google quickly concluded partnerships with high-profile university and public libraries, University of Michigan, Harvard, Stanford, Oxford, the New York Public Library, and of course, in 2006, the University of California system, providing digital access to a portion of the 34 million volumes in the 100 libraries that are managed by the UC system. So this is a really direct relevance to us as well as to all of the other users in the US and around the world. So according to Google, they had scanned 7 million books last year, more, who knows, remarkable, whatever the number is, and tremendous investments. The initiative has been hailed for offering unprecedented access to what may be the largest online corpus of information, the digital age equivalent of a card catalog with every word in the publication indexed. We know that it's also invoked great opposition. In 2005, the Authors Guild of America and the Association of American Publishers separately sued Google, citing massive copyright infringement associated with the Google Books project. Flash forward to 2008, the settlement that was proposed after 2 years of negotiation, called the Google Books Settlement, is what we'll discuss today. It allows Google to provide greater access to even more books at present and to offer some new services. This settlement will be approved, still has to be approved, by the US District Court at a fairness hearing held in October. Many of us wanted to hold this conference as soon as possible because comments from the public are due in next week, I believe. So I think it's clear that this settlement will have a profound effect on future digitization efforts, on the market for books, the role of libraries, scholarly research, and just general users' access to information. So our goal in organizing the conference was to allow us to have a conversation about the opportunities and the risks of the proposed settlement, bring together a range of voices and opinions on some of the most significant issues that the settlement raises. What we chose to do is organize this around discussion today around 4 major issues. You'll see that some issues that have been in the media a lot are not going to be covered as explicitly, for example, the antitrust issues, but they may come up nevertheless. The 4 panels that we've organized today, beginning with the potential foreign restrictions on research into the content and the use of the collection, data mining. Second, the questions of privacy that inevitably arise from creating and controlling access to this kind of collection. Third, the quality of the content and the metadata surrounding it. And fourth, the right of the public to have access to works embraced by such a settlement. We've consciously limited the time that the speakers have to present their perspectives. We've tried to get a balanced set of views in order to leave lots of time for discussion among the panelists and for Q&A. So this is really an opportunity for us to have a dialogue. And we've also scheduled half-hour breaks between the panels to give you a time for just the kind of conversation that we often have offline. So with no further ado, it's my pleasure to introduce the moderator of our first panel, Eric Kansa. Eric is a professor at the University of California at Berkeley's School of Information and Executive Director of the Information and Service Design Program and Clinic. Eric, I'll let you introduce your panelists.
Thank you. Thank you, Anna. Before I introduce the panel, I want to give you a little bit of background around why we're going to be looking at the question of using this vast body of literature that Google has put so much effort into amassing and collecting and scanning, and using that literature not really for humans' eyeballs to read, but for machines to read. And what are the potentials, what are the future applications, and what are the usage questions surrounding that? I want to first off mention that one of our panelists, Colin Evans with MetaWeb, sends his sincere regrets that he was struck with flu, and I hear that's going around this year, and isn't able to join us today. So just to start off, we should briefly mention what the scale of this is that we're talking about. As of last year in the fall, Google publicly made a claim of around 7 million books being publicly available through its book search project. Other observers who have been working with libraries and monitoring the process and the progress of Google's scanning efforts may estimate that there's something like 15 million books that Google has scanned. So this is a tremendously large body of work. How much is that in terms of the total universe, the total population of books that are out there, that are available? Census data, collected by the U.S. Census, estimates that there have been some 2 million books that have been published since the 1880s. WorldCat, which has the largest single catalog of books, has some 23 million books in its collection. Other estimates, thinking about the types of books that might not be indexed and cataloged in any of these collections, range even up to maybe 100 million books. So the sample that Google is collecting is a tremendously large portion of the universe of world literature. Now, an interesting question is, once you've scanned all of these books, what do you do with the million books, or 23 million, or whatever the final number is going to be when the scanning project's over? Greg Kane, a leading humanist working with computer applications in the humanity, asked this question back in 2006. Well, there are several commercial applications, and I hope my panel will be able to address some of these things. And there are also several research applications. Some of these research applications are happening right here at UC Berkeley. One of my panelists, Jim Pittman, is leading a project called the Bibliographic Knowledge Network. Other members, my colleagues at the School of Information, have been doing a lot of work mining literature, historical literature, to extract interesting information to answer important questions in the humanities. There are important applications that can be related to improving the processes by which we extract information from large bodies of text. Knowledge synthesis, of understanding relationships between concepts, of important kinds of relationships, of historical significance, historical context of what, when, where, and whom. Of course, there's also an unknown future application in this space that we really can't fathom right now until researchers really have the opportunity to deeply explore this kind of data set. And you never know, maybe this data set will provide the basis for future understandings about how culture changes and evolves, and maybe a Darwin-like figure might create some interesting new theoretical ideas about cultural change. Now, in the commercial space, this is something that is not just sort of pie-in-the-sky things that are possibilities, but these are actually real companies with receiving real investment and offering real services that are deployed here and now. MetaWeb is one of the leaders in this field, and it's our loss that Colin won't be able to make it today. But there are others who are working with large bodies of text, extracting meaningful, useful knowledge out of these texts, and then offering this knowledge to users as services. Wolfram Alpha is another famous example, and it is now working with Microsoft. And PowerSet, a natural language search service, was recently acquired by Microsoft. So this application area is receiving a great deal of commercial investment, and there seem to be no end of opportunities that can be supported by working with large data sets of textual information, extracting valuable factual data out of these works, and then presenting that to users, especially when we consider that we can present these things to users along with a whole range of other data sets from other domains, such as the World Wide Web, or even data sets acquired by studying and monitoring the interaction of users with these systems. And this is one of the things that could be a topic of discussion later on today in the privacy section. So in some ways, a data set like this vast corpus of literature, is somewhat analogous to a cultural genome, or at least a literary genome. But there's some important distinctions and differences that I hope that we can explore this morning. The Human Genome Project received significant public sponsorship to create and is now largely in the hands of the public trust. It's largely in the public domain. The Google Book corpus is in a much different kind of a circumstance. And the settlement will be outlining different kinds of access rules, different kinds of restrictions, to a very different kind of body of data than base pairs in our human genome. So the kinds of questions that we want to address are what are the implications of these restrictions and opportunities for researchers, for the public, and for future commercial innovation by Google and by others. So one of the big questions to think about in this, and this is one of the areas that probably hasn't received significant attention in the press, is it may be that this corpus is going to be primarily valuable from what it can offer through machine processing, not through human eyeballs. And how will this settlement impact? Who's going to benefit from that? So these are big kinds of questions. Now, I want to introduce our thought leaders on this. And I first want to introduce Peter Brantley. He's now with the Internet Archive. He's their Director of Access. He is a longtime leader in the world of digital libraries and has been very outspoken about various aspects of the settlement. And he will be presenting some ideas about the settlement and maybe some of the implications about how the settlement will be shaping the future of using this as a data set. I also want to introduce Professor Jim Pittman here at UC Berkeley. He's deeply involved in some of the fundamental research involved in data mining, text mining, using these large corpora of texts as resources to extract meaningful knowledge. And he's director of the project funded by the National Science Foundation, the BKN project, which is to develop visualization tools and innovative services in support of scientific communications and scientific use of literature. So I think that they will have tremendously valuable insights about the nature and the scope of the settlement and how it's going and its impact in these crucial areas. Now, to give everybody a background about what the settlement actually says around some of these issues about data mining and these sort of non-reading uses, first of all, the settlement has very little in the way of, there's very little restriction in terms of what Google can actually do with this corpus to develop and enhance new services. These are non-display uses in some of the terms of the settlement. One of the more interesting aspects of this in terms of the research community is that a research corpus, this body of literature that Google has scanned and digitized, will be made available to researchers to engage in innovative research projects. Qualified researchers can experiment with this tremendous resource, and the algorithms that may be invented from this, using this corpus, really don't have any strings attached. So in some ways, for some aspects of the research community, this seems like a tremendous boon, having access to a huge data set to experiment with and to develop new and interesting innovative tools around this. Now, some of the topics for discussion, though, are going to be relating to how all this will actually play out if the settlement is actually put into place. So the settlement is going to make this research corpus available at two host sites who will be responsible for evaluating proposals, running audits to make sure that whatever is used on these corpuses is not in breach of the terms of the settlement, and they are to make sure that the people working with the corpus are qualified to do so. One of the questions, and given that the scope of this settlement is huge, it's a very long and complex settlement, and I'm sure that there are many issues that just can't be addressed in this, but it's something that we should raise and have some concerns about, are just how will all this actually play out? What's going to ensure fairness about this? Who's going to evaluate the proposals for research projects? What pressures might be faced by host sites from Google and from the rights holders about the kinds of research that can be performed on this corpus? Another kind of question around this is that the settlement makes some restrictions about how this corpus can actually be used. One of the most important ones, especially in terms of working through this in the context of the developing commercial landscape around text mining, is the need to get permission from the registry and from Google for commercial use of all the information extracted from this. So, the question for the panel and for our just discussion today is, how is this going to impact future competition and development of commercial services based on this? Another interesting issue is that rights holders may demand the removal of any and all data extracted from books. Settlement also prohibits use of these data extracted from specific books to provide services to the public or third party that actually competes with Google. So these are, again, how does this play out in the long term? And what are its implications? Now, there's a traditional distinction that U.S. law makes between public domain facts and ideas and copyright-protected expressions. Does this settlement change this dynamic? And will the settlement create basically a type of controls over facts and expressions that really are somewhat novel to many members of the public and also to many researchers? Another issue is that qualified users who are building services on this can't build anything that's competing with any services that Google offers. Now, this is an interesting kind of a question about actually what that's going to mean and how that will actually play out. One of the big concerns about researchers is that research requires scrutiny and evaluation of methods and sources in order to perform research in any domain, including in the humanities. And does the settlement actually permit a solid enough foundation where one can scrutinize the underlying algorithms, the data sources that go behind use of this corpus? Or is the settlement going to lead to a situation where we have to sort of trust that whatever is developed, whatever services are developed on this, are going to work, and it's going to be more or less a black box? So this is a question that we want to raise in our panel. So, just to conclude, and before we move on and have Peter make a few remarks about this, really, how will this settlement shape the long-term future of literature as data? And this is an interesting kind of question because how this plays out could impact the shape of this corpus and use of this corpus for many, many years to come. Thank you. Peter.
Can I?
Sure.
Hello, everyone. Thank you for having me here today. Sorry, hang on. Yeah, sorry. So this is a tad earlier than I usually make any kind of semi-public or public appearance. So I'm prone to flip between jittery and catatonic. So if I go too far in either direction, I hope somebody will appropriately jab me electronically or otherwise. I am thrilled to be here. This is my first time in this building. I used to have an office, courtesy of Tom Leonard, the university librarian, here on this campus when I was working for the Digital Library Federation. And it was fascinating to walk by and just watch this building go up in what seemed, for a public institution, a remarkably short period of time. And so I was actually astounded to realize that we were going to be having the meeting here. And it's a beautiful building. So congratulations to UC, to UC Berkeley, and to Citrus for constructing such a phenomenal facility. I also want to thank Anno and Eric for having me here and participating in this delightful group of folks talking about some very complex issues. And many of you know also that I work not only at the Internet Archive, but I've been working on a group of organizations that are coming together to articulate a set of concerns about the settlement called the Open Book Alliance, and we'll be continuing to articulate our views as a community of organizations, libraries, authors, publishers, and corporations in public venues as well as in dialogue with government agencies. And I'll raise a couple of concerns about this general topic toward the end. But first, let me grab water. And I sort of want to echo, there's this tremendous opportunity here that all of us face that, I think we all have to pay homage to this amazing ability to conceive of mining books, of working with books in a new way, of being able to obtain the information from them, not just simply exposing a book as a book for discovery and even elemental access, but discovering book as a container for something more fundamental and I think more distinct and more, in many ways, as Eric said, more valuable. When I give talks about the future of the book, I usually quote very early on in a slide deck. I have no slides today, sorry. But I usually quote very early on something that the critic I.A. Richards said in a book called The Principles of Literary Criticism, 1924, just after that 1923 cutoff. And I.A. Richards said, "A book is a machine to think with." And really what he meant there was in a different context. He meant that a book is a product of a series of social evolutions that allows us to come to a place where we think of a book as a product that is sort of maximally designed to facilitate our interaction with it. We've grown to know books as discrete objects. They're of a certain size and shape. They have a certain mechanism of action, of turning pages. They work well with what we are as a biological being, as a learning being, and as a sharing being. Right? So the book is something that has been developed through an industrial process, through a cultural process, and indeed through socio and political processes. Right? And so this is the conception of books that we labor with now on the threshold of a very new vision for how books might be used. And I think that we have to realize I think it's hard for a traditional publisher to realize this, but we're very much moving from a world where books are just books to where books are data. And thinking about books as data means that we're thinking about how to utilize books in a wide variety of new ways. And it's not just that books are data in the sense that books are bags of words that can be thrown into a single pot in mind, although that's a critical piece of what books offer. Containers for various rich troves of knowledge, of attributes, and so forth. And that those attributes, those knowledge attributes, can be linked together across books to create new products. Right? So there's this value in the book, when you think about the book as data, that's definitely greater than the value of the book itself. And so, this bears also in publishing when we think about new books, when we think toward a future of trying to figure out how to tell stories in the future. We won't be just printing a book and selling it in a bookstore. We'll be designing new kinds of books that live a little bit closer to this vision of books as data, closer and closer as the years go by. And this future transition is actually very important because we can't get stuck in a notion of thinking about the old books are now in this corpus at the Internet Archive or at Google Books or anywhere else, and those are the books that are bags of bits. And then we've got new books. And it's not like that, right? Because the new books, first of all, are increasingly digital too. But even more critically, our notion of what a book is will be changing and affording us whole new opportunities to think about how we work with books and what books mean to us, provide us new opportunities to integrate new books into the old books and reconceptualize questions that we probably cannot even imagine right now. So this sort of analogy that it's a horrible one, but I come from a sociological background. But in a sense, we're moving from a Gemeinschaft version of the book to a Gesellschaft version of the book, in the sense that we're moving into a society of books. Right? We're moving away from isolated community of the book into a social model of the book. And that's really a far more important place. So as we move into that, there's this opportunity to link data that's held in the books with other data that resides in other systems. And certainly this value that the books contain, so retrieving the facets of the books that represent ideas, that represent biographies, dates, and other critical aspects of information, and pulling that into a rich creative weave with other products that are information-based is something that is critical. It's a critical offering of a large corpus such as Google Books. And it's certainly something that I know that my colleague at Google, Dan Clancy, is very much concerned about and very much engaged in working to achieve. And certainly, who could blame him? So I want to just enunciate a few concerns that I have as we move into this world. First of all, to some extent, as Eric has suggested earlier, there's a uniqueness to this corpus that is unexcelled. This is a comprehensive collection of 20th century literature. Anyone else confronting this body of literature will not be able to achieve that level of comprehensiveness. This is an exclusive deal that Google would get through the class action settlement. And it's exclusive because through the class action aspect of the settlement, no one else is going to get access to works that are not registered or claimed, including orphan works, without the risk of lawsuit. So there's value in this comprehensiveness, right? And it's something that we need to think about, that scholars and researchers need to think about, whether or not they want to entrust a single comprehensive collection to a single corporate actor. I think, that way lie many dragons. And authors, even if they pool works, Google will still be able to utilize, in many cases, those works for integration into other products, like Google Maps or other types of Google products that might pull upon the richness and variety of knowledge that are held in books. And that's a very interesting thing, to know that as a rights holder, I can't pull my book from the corpus for example, data use only, right? I can't do that. And even if I pull my book for display uses, it's still there. So I think there's a little bit of this as we think about what we can use this corpus for as scholars, kind of the rich mining, the opportunities for creating live translation services, for adding value to other products. We have to think about our responsibilities as scholars moving forward. And part of that responsibility is in noting that we don't have to create societally a single provider of a comprehensive collection of literature for the purposes that we can envision in the future. I think we have a responsibility to think through how to create a plethora of options, because there will be a diversity of possible uses of this material that we can't imagine, that should not be held uniquely. As scholars, we live in an environment of an academic institution that in many cases now is struggling under severe financial pressures. And yet this corpus will be sold back to our institutions at prices that might be unregulated, that might put tremendous pressure on the institution, where every institution will feel the need to acquire this product and put out of bounds perhaps other resources that have other value. So the consequence of that is, as scholars, do we think about alternatives? Do we think about other ways of working toward a future where this corpus might be available under better terms? We don't have to grab the cookie that's offered to us before dinner. We can think about other ways of achieving this goal. We all know the value of this data. In all of the fields represented here, we, Google, the Internet Archive, other search companies, other knowledge extraction companies, we all see the possible value of this data. So there are many other paths forward. We can do better. We could, for example, imagine a scenario where the corpus is licensed under a compulsory basis. We can think about other ways of opening up access to this data as a society. We don't have to think about it simply in terms of settlement, no settlement, Google-provided corpus, or no corpus. There are options that we can think through, that we can debate, that we can value, that might have different impacts on our institutions than allowing Google to have a monopoly of access to the database and to govern the content and restrictions upon which it is accessed by others. This is a tremendous time, a tremendous moment in history, where we have this incredible opportunity to look back, to pull into the future important pieces of information and knowledge that were hidden, that allows us to integrate those pieces of knowledge into new visions and confront new dangers, and to integrate that into, as I've said earlier, new visions of what the book, what the journal, what the expression of ideas can be. So I ask all of you, think with me, how can we make that future a compelling future, not only for scientists, but for our institutions, for our universities, for our states, and for our societies? Thank you.
Okay, I'd like to invite Jim to make a few remarks now. Jim?
Sure. How are we doing on time?
We're fine.
There's tons of time.
Plenty of time, yeah.
So thank you very much for the opportunity to talk here today, and I hope I can engage some of you in contributing your ideas. I'm know rather little of details of the settlement or the legal issues. I think what I may be able to bring is some indications of what the academic community might be able to do, and with information like this, and how somehow the various many participants, potential contributors, should have the opportunity to add value to a corpus like this. So there is a feeling that there's the content of all the books, and somehow that of itself is going to be, it's a tremendous resource. But there is also the, what's in the heads of the people that are reading those books and how they can add value to it, and integration of what people are doing in their ordinary academic lives with the information in these books. So if I make a product through my professional community, which draws on some information from Google Books, some information that I know, some that my colleagues know, at what point do I start violating some sort of an agreement that I can't make, I can't show this data from Google Books in bulk? I mean, there are lots of things. I'm particularly interested in things to do with subject navigation, classification. This is a very difficult problem that librarians have dealt with for a long time. How do you divide up the universe of academic interests into subjects? How are subjects related? How do they develop over time? Information about this, a tremendous amount of it, is there in the text data and other structured data, the metadata associated with books. Now, the Google Books undoubtedly can contribute massively to that, but there are other, agents who have a stake in that. I mean, who owns these concepts? Mathematics, statistics, probability, combinatorics, the relations of these subjects. These are things that can be inferred and extrapolated on a massive scale by analysis of a large book corpus. But then by virtue of analyzing such a corpus and coming up with, say, a subject classification or fuzzy subject scheme, ways of navigating around, people who like mathematics also were interested in statistics, also were interested in economics. There are also many, many kinds of services and things that you could imagine using or feeding Google Books data into. And at what point is that a competing service with Google? There's a lot of gray area there. I'm very interested in those with more legal experience and knowledge of the Google settlement to comment on the extent to which Google's ownership of the rights to disseminate this information could inhibit what would be, I think, tremendously useful developments of sort of map of knowledge, helping, assisting students, scholars at all levels to understand how what they are doing is related to what others have done or may be doing. These sorts of things I see as potentially tremendously valuable applications of the Google Books content, and I question the extent to which the scholarly community may be inhibited in developing such applications by, copyright agreements or license agreements in the settlement. One of the points is that whatever data structure is provided there in Google Books, in restricted parts of it, there may be other structures which are of great interest. Chemists are interested in chemical compounds. Mathematicians are interested in theorems. These are subject-specific structures which can be mined by text analysis of books. Now, who decides whether, I can mine the book to find problems or theorems, or some chemist can mine the book to find chemical compounds? Do we have to ask for permission? I would rather not. I mean, I don't like the idea that there is an agent that is controlling whether I can do research or some imaginative mining, structuring of data, and that when I'm all done, when I have my tableau of theorems, or when a chemist has their tableau of compounds, that the use of this might be restricted because of that, analysis of text from Google Books was some component. These are concerns that I have. What else to say? I think if there is lots to be done by text analysis, if you cannot get the data on your own computer, or if you don't have very good access to the data, you are not going to come up with creative ways of using this material. So it is very desirable that the data be available as openly and as freely as possible for the use of researchers to do creative things. We haven't yet imagined the creative uses of the data. The data is so vast, there are so few people, agents that are competent to really extract what is already there. Undoubtedly, Google and Google staff, they are amongst the most skilled and most competent at extracting information, but there are other players, there are other algorithms, and I think we could benefit from seeing, the uses of that. Now, if Google only has the right to give permission, Google senses a competing algorithm, competing service, competing product. They have a commercial interest to stifle innovation in the general domain of extensive text processing, derivation of structure from text, and so on. So those are broad themes I'm interested in. Maybe I will comment on a few specific applications that I would like to see that require additional effort on top of the just plain text mining. So things like identifying people, places, events. You can do this roughly with text analysis, but to go the extra way, and you have books or references to John Smith. Well, exactly which John Smith are we talking about? You can use machine learning algorithms to infer that the John Smith that's being talked about in this book is probably different from the John Smith in that book. They might have birth dates that were different, and you may or may not be able to get this associated information, birth dates, where they lived, things like that. So you can do a lot of entity extraction and disambiguation of text by machine learning methods. But in the end, to get the best product, you want to get people to actually look at what the machine has done and say, yeah, that's right, this John Smith is really different to that John Smith, and we should, in a database of people that we're interested in, we should have two entities, and they should have, different sets of text references in the Google Books data, and so on. So if you think of, taking things that extra mile, and you start, there's a disincentive to do that, or a difficulty in doing that, if you always need permission for every little thing like that. I think that individuals or small organizations should be encouraged to cultivate the portions of the academic universe that they know and understand, to use whatever resources they can get hold of to inform that map and that study. And Google Books is likely to be a huge part of that, but there are other things out there. We want to combine the resources, and I'm concerned about inhibitions to doing that sort of thing. Perhaps that's enough. I'd like to be glad to contribute to discussion, but I don't want to continue, with too much more.
Okay. Thank you, Jim.
So, I'd like to open up the conversation to include people in the audience. And when you ask a question, please do use the microphone to speak into. We are going to be recording this and making this more generally available. And I think it would be probably useful and good now to move on and actually have Google, the Google book search, enter into the conversation now. There's a lot of potential application here for researchers. Jim mentioned a very interesting point, a very valuable point about the need for people to interact with their algorithms, to see their outputs, to actually check on things. And I do believe that the settlement actually makes some provisions in that regard. And Dan, would you like to jump in and join the conversation now, please?
You know what might make sense? Because to help us, Jim, I think a lot of your points, it's a good point to kind of just talk through some of them. And what might make sense, Eric, is to make sure that as people have questions, if I could be where we're not having to run the microphone back and forth, because I think getting in discussion of some of Jim's points, so we only have, maybe I'll come up there and that way, because I think there's a lot that you had said and that's important, to kind of understand, you said, well, I'm not a lawyer, I don't understand all this. And in fact, in this particular case, I know this very well because, I wrote a lot of the words here. And in fact, a lot of the concerns you had, it was designed to avoid exactly that. And so I'll quickly try to help clarify, and then let's just, I think getting discussion is really helpful. So quick question, how many people here have access to 10 million books right now to do data mining? Please show your hands. Okay, so I do, because I work for Google. Okay. Now, if the settlement doesn't get approved, how many people in this room would have access to 10 million books for data mining? In 8 months. In other words, if the settlement gets rejected in October.
$1.5 million.
$1.5 million, okay.
Right.
Open Library has $1.5 million. That's already very useful.
Yeah, 1 million of them are from Google.
Yeah.
And we're distributing them too.
Dan.
Okay, but we're distributing them too. In fact, we're working to make our public domains. In fact, our library partners gain access. They actually have subsets, right? Every library, anybody here from UC would have access to, some 1 or 2 million or something like that. And one of the things in the settlement was we actually believe non-consumptive research is fair use. We don't think we need the settlement for this type of work. None of our library partners felt they needed the settlement for the work. And one of the real benefits we thought was the research corpus to help, address some of what Jim's talking, because we share completely the value of this and that we think it should be broadly accessible. So I'm going to a few of the concerns. The way it's structured is you don't have to ask permission to do anything. Okay? And Google has no say whatsoever in what you do. It was designed so that the host sites, which will be the libraries that pick the host site and run it, is that the libraries run it. In fact, at some point, they actually had talked about Google running the research corpus. Okay, because, well, wouldn't it be nice? Y'all can run these things. And I actually argued strongly against Google running the research corpus because I said, no matter how Google acts, there would be this sense of Google looking over your shoulder. If you're doing all your research on Google's machines, then when does Google decide you shouldn't get access? And that's why I thought it was very important that the universities, I say libraries, but it's really the universities, run the research centers, much like universities run the PACI centers or the census or many other centers. So Google has no say in what you do on that corpus. Okay, you do need to demonstrate that what you're doing is non-consumptive research. And so if it's, if you were doing new search technology, you tell the host center, not Google, you write a line that says, I'm doing research in searching over large textual material, right? And that sort of shows, okay, that's clearly non-consumptive. That's, and the host site is responsible for just making sure that the reason you're accessing this is actually the reason it was created. It isn't to read the latest version of Twilight, but it's to do all this. And so that's one important thing to note. And that, there are some provisions when it talks about the information extracted, which I know is one of the concerns. And I'll use a few examples, and I think part of the discussion going through examples, because writing this in legal terms was ridiculously difficult.
Oh, I'm sure.
Because we were trying to describe something that
we still don't understand as a community. Okay, we don't understand what all these potentials are, what all the possibilities are. And so trying to articulate this in some legal fashion was challenging. So let me distinguish a few things. Suppose you infer from the text of a book what the subject of that book is. In other words, as opposed to using, or you infer a bisect code for a book. Suppose you use the text to infer a bisect code. Okay, that's yours. Okay, that's not the concept of the information extracted. Okay. Now suppose, in contrast, you take the full corpus and build an index of all the books in the corpus. Okay, you take 10 million books and you build an index and you say, now I want to take this index and start offering a service. And I'll call it derived from Google Book Search. Okay, that then would be limited. In other words, you can't take an index of all the books and start offering an equivalent service to Google Book Search. Okay, and I've never thought that was extreme, given that Google's spending the many millions of dollars to create it. Similarly, if suppose you wanted to create a concordance of all the works of Elsevier, and Elsevier actually sells a concordance, then Elsevier can say, please don't take the stuff from my books that I gave you permission to look at. Okay? They can't affect you at all with any books that aren't theirs. Only if it's competing. And so this was this edge case. And so we designed it so that it was really permissive about research such as yourself that could come and, you're going to be learning new things. I mean, an example, there's a group at Harvard that's looking at irregular verbs. And in fact, they're working with us. We're providing them access, but it's very limited because we have copyright risks, so it's only when they're students working for Google can we let them access. But they're looking at irregular verb usage over time and inferring lots of interesting things from it, right? And that sort of thing is all at the discretion of the researchers. So, one of the things that I think needs to happen in this, and I encourage people after this, is engaging in a discussion with the universities that if the settlement were approved, how to build such a resource to make it easy for researchers to come use. And that's not a Google problem. That, in fact, is your problem in terms of the partner. So with that, maybe I didn't go through all of the points that he mentioned, but I think it's good to get going with the conversation.
Thanks, Dan.
Yeah. I'll sit.
So, I'm going to invite some of the panelists now to respond if there's anything any other questions that they want to ask about what Dan just said, or if they want to make a point of comment or disagreement about this.
So I appreciate the point about not providing a direct service, but let's say I want to create a service which indexes theorems in mathematics. So that is, first of all, I have to go to a lot of trouble to find which Google books have anything to do with mathematics. Mm-hmm. It's not so hard, but it's still non-trivial. The metadata is rough. Anyway, that's already that kind of bulk classification problem is already interesting and important. That done, I have to get in there, see if I can recognize a theorem when I see one. All very difficult to do in bulk on dirty data, but imaginable that you might be able to do something. Then I do this. I create a database of mathematical theorems, and I build a service over it. And I don't know, maybe there's a business model, maybe there's not. Right? I mean, maybe it's commercial, maybe it's. Yeah. So can I do all that? Whose permission do I need to? Meanwhile, Google is doing it. Hey, Google, it's a great idea. Let's do a mathematical theorem service.
Yeah.
So at what?
Yeah. At what stage? No, that's a good. It's a good example. That and let's break apart the pieces. Okay. Mm-hmm. So one piece is you're doing all this, figuring out smart algorithms to extract theorems, right? And that's all yours. Mm-hmm. There's no questions, ifs, ands, or buts about anything with respect to that. Okay. So then you run this smart algorithm over all these books, right? And you find out, let's assume right now, for example, suppose you built an ontology of theorems.
Yeah, good. Exactly.
Okay? And you build this ontology of theorems, and then there's a link wherever a theorem exists in a book. Mm-hmm. okay? And so now you can search the ontology of theorems, find the theorem, and go through that link to the book.
Yes.
Okay? So the information you've sort of extracted here, because the theorem, as you pointed out, theorems are sort of exist in space, intellectually. Really what you've extracted is this information that this theorem is on this page of this book.
Exactly.
Right? So
it's an indexing service, and
Yes.
it's very, very similar to the kind of service that Google provides. And
Yes.
I'm worried that you will interpret the legalese
Understand.
to say that if I provide a decent service that actually made money for me or somebody else,
Yes. Yeah.
then, oh no, you can't do that. That's Google. The legal
Right.
settlement says Google owns all that.
Right. So now, first of all, it is the case, and you talked about this, that if it's a commercial service, okay, we did not get permission from the rights holders in the settlement to allow commercial services. Part of this, again, is they don't know what we're building here. Okay?
Yeah.
You can build commercial services off of your algorithms. It's just that little link because they gave you permission to access their book. Okay, so to be clear, if it's selling the information, right, at this point we did not get permission from the rights holders for that. Okay? Now let's focus, and this is a good example, let's talk about non-commercial. You're offering a theorem, this is a perfect example where a theorem prover, we don't see that one as a gold mod. So one of the things in here, it was designed explicitly to address the fact that, I don't think a theorem indexer is competing with Google Book Search. I mean, we don't have a theorem search. I mean, what you're doing here isn't, you'd be doing far more than what Google Book Search does today. So I don't think this competes. And in fact, it was designed so that Google can't then subsequently say, hey, that's a good idea.
Yeah, this is the concern.
Right.
Precisely.
That in fact, they can't say, it has to be that they were already doing it. So we can't, let's say you do this theorem thing, right? And then, Google says, ooh, that was smart. I want to go build a theorem search engine, okay? Sorry, you've been already offering it. Google, if it looks at the smart things you did and then wants to build that service, then that competing service didn't exist when you started to do this.
So is there a list of Google services that...
So in this, and first of all, I think it's one thing to, there is, is there a list in the settlement of
Yes,
where?
yes.
No.
Okay.
No.
Well,
Dan, I want to give Peter a chance to jump in.
I think it's important. My points are orthogonal to this conversation. So let's continue on this theme of trying to delineate out, what Google understands its interpretation to be of valid uses of the research corpus and how they're leveraged by faculty or can be leveraged by faculty.
We could maybe go away. I mean, theorems or chemical compounds or something like that is very subject specific. But there are certainly things that cross all disciplines. One, entity extraction, especially of people, places, and subjects in books.
Yeah.
And I was trying to think of one that would be of interest to humanists and books that weren't about, weren't science books or weren't factual books. And one that occurred to me is classical allusions. So if you had an index of where, you had your favorite classical myth or allusion, an index of all the places that was mentioned in a book. I mean, that's, in principle, could be done with text mining. Highly non-trivial to do it at all well.
Yeah. And I would not, and understand when we're writing the legalese, you use the example of, I use the example of taking an index of all the books, right? And it's like, oh, that makes sense. And so we're trying to get words, right? And it's always hard with this thing we don't understand to deal with this one example that everybody says, oh yeah, that kind of makes sense. Okay, and so as you were talking about the illusions, I would not consider that competing with anything that we're doing. Okay, and in fact, I think what we're doing now, in terms of Google Book Search, is fairly clear. It's kind of a well-defined thing, searching over all the books. So I think.
How about people and subjects? And
so I
places?
think people and subs. So for example, let's take the thing that you just said, that disambiguation of people. That in fact, one thing that you can do is learn an algorithm to do the disambiguation and building information about people based upon the context in which they're used, so that then when you have another book or the web Let's take that example. That in fact, because of what you've learned from the books, you can now look at a page on the web,
Exactly.
and you see Jim Neal on the web, and because you built a model about the words that are used within the context of what I'll call is Jim Neal 1, particular Jim Neal, okay, you have a model of what are the types of words used proximate to Jim Neal 1. So now when you see Jim Neal 1 on the web, you can say, or Jim Neal on the web, you can say, oh, this is Jim Neal 1, because you match it against the model.
Exactly.
Okay, I don't think that is, I think that's no problem.
I'd like to get back to a point that Jim made earlier when you were talking about use of this corpus when you're combining it with data sets from other sources. And you say you do some sort of a mashup, a research mashup, where you're taking a lot of data from the corpus, a lot of data from other places, and you want to present these data as a research product in itself. And you have these strings attached, I suppose, from the settlement about rights holders having the some power to say that please strike your these factual data from whatever subsequent uses are. One of the wonderful things about this conversation is that this room right now has a great deal of legal expertise. And I would love it if some of our colleagues from the law school would be able to help us unpack some of these kinds of questions, because this seems like a difficult area. As Dan was saying, that trying to write about data in the settlement you had a really difficult time with. And if Pam Samuelson, Jason, somebody would offer a legal perspective to help delineate where some of these issues really are.
And actually, can I just also, going back again to this topic that Jim raised, creating a service that Google theoretically could provide an entrant to, and if Google did later decide that that was a worthwhile market, it seems to me that it has mechanisms by which to, in many cases, make a vastly improved offering in the marketplace, and therefore has a privileged position in terms of market entrance based on its ability to mine and integrate this data. And it's an interesting question whether or not Jim, as a researcher or potential working at a university that's a licensee of the database or a registered user of the corpus, if he has any wherewithal to file a complaint against Google in a court on the basis of that action.
I'm not sure, meaning if he patents an idea.
No, if he's running a service, if
I
he's
can't
building a
run a
business.
commercial service according to big terms.
Right.
I can't build any commercial service. Can I build a non-profit service?
So let's be clear. So Jim, you can be building commercial services in terms of the algorithms. Let's say you learn a automated translation, right?
Yeah. Mm-hmm.
And so now you have an algorithm because you've used the parallel corpus. Now that is the intellectual property, that's your algorithm, no issue.
Yeah.
Okay. It's only when you're building, extracting the information explicitly from this book.
Yeah.
Okay.
Suppose my service is you give me a name user provides a name like Michael Jordan, and then the service comes back, well, Michael Jordan is a basketball player. Michael Jordan is also a researcher in machine learning at UC Berkeley. Here are all the references to Michael Jordan, the basketball player, in Google Books, and here are all the references to Michael Jordan, the machine learning guy, in Google Books.
Let's take that.
So that would require real effort with algorithms to do. That's a fairly easy disambiguation, by the way, compared to two different John Smiths writing mathematical theorems, right? Much harder challenge.
Yeah.
But there is peripheral information around the names, which is there in bulk in Google Books. And
absolutely. And so using that example, and part of the understanding this, many people, and those who have worked with publishers and authors to try and negotiate rights, a lot of times there are folks trying to get these rights when they license databases today. Mm-hmm. They understand that, when we first started this, the people, even on our team, when I was saying, oh, let's get this in, and the library was saying, let's this in, they thought we were crazy that we could get the folks on the other side to understand what the hell we were talking about. Okay, so the fact that we got as far as we did with this area where they're not computer scientists. Okay, so yes, they had lots of trepidation of what they're doing here because they were like, well, wait, am I giving everybody the keys to something I know nothing about? Right? So there was trepidation, and so there was apprehension about letting people access, commercial because they're thinking, oh, well, wait, now it's going to come and, and compete. And so in this case, I can't imagine why you couldn't get permission from rights holders. In other words, for a service like that, it's in their interest. It helps us.
So what does that mean? I have to get permission from rights holders.
Yeah, for a commercial to start a business.
But who do I get that from?
From the registry.
Huh?
From the registry.
But I think this gets to some of the questions we raised earlier too about, is this sort of breaking down some of the barriers between the fact expression issue and being in the public domain and copyrightable expression. It seems like this is moving this issue, these sort of factual kinds of data into more of a protected kind of a realm.
It's actually, so in this, understand the difference between a contractual license to do something versus, so anyone can scan the works and still do this, okay? There are people that, suppose you went to a publisher and you were subscribing to all their stuff, right? Now you're getting a license to all their text. Okay, there's the question of what are you doing under license from the rights holder, okay, versus what you do on your own. So to the extent you scan the stuff, there's absolutely no constraints, okay? To the extent you're doing it under a license, and this was one thing that was in this fact expression, okay, it is the fact that the creation of the research corpus was designed for research, not for taking data from here and then starting lots of new businesses, okay? I can understand that we'd rather also the ability to start businesses, but we were starting from the current situation where this data wasn't accessible.
Yeah, so
the
agreement talks sorry.
Yeah, let's, is there anybody in the, yes?
Could you get kids up?
Can't,
I wonder if Mr. Brantley in particular and anybody else who cares to would address a problem from a critic standpoint, I guess. It's my understanding that the judge in the case is formally very severely constrained in what sorts of concerns they can act on, and that they, I think, would have to base any modifications or rejection on the interests of the class members, which would exclude a lot of social considerations that you're interested in. How true is that? And if so, what does that behoove you to do? You mentioned going to the agencies. What are your avenues for relief from whom? The judge, federal agencies, and others.
Could you please identify yourself?
I'm Louis Traeger. I'm a journalist with Communications Daily and Washington Internet Daily.
Okay, so first of all, I'm not a lawyer, and so I don't wish to discuss in any detail my perception of what Chin at the district court could say in relation to the parties in terms of making recommendations about the settlement and how it might be textured for approval. I think that the court's procedures are public and can be verified by reading them. As far as the Open Book Alliance is concerned, our effort is to articulate the concerns of our membership relating to the impacts of the settlement and to eventually raise possible paths forward that might alleviate some of those concerns. And we would certainly attempt to engage any government agency involved in an inquiry into the settlement or indicating concerns with the settlement.
Okay, thanks. Jason.
Hi, so I am a lawyer, so I'll at least try and address some of those in reference to, I think, what is a good context for this entire event. And just for reference, I'm a clinical professor at the law school. So I think what's important to distinguish here is Google Book Search and then the Google Book Search settlement. right? So Google Book Search is currently a product. It works. It does a lot of really amazing things. It's continuing to go. Google's continuing to scan. And in fact, and I'll speak a little bit to this later, I mean, what's exciting is the sort of stance, to me anyway, that Google's taken on fair use and other issues before the settlement, right? So some of these issues about access to data, I think the right answer is that they're not protected by copyright when you extract them for the purposes of transforming them into knowledge and access and some of these things. What's interesting about the settlement, and I think there are pros and cons to it, is the settlement is much broader than that issue. It includes a lot of issues, and it also sets up a legal regime to which Google is bound, and to which a lot of rights holders are bound beyond those who are represented directly in the lawsuit, right? That's part of why we're here. So this judge does have to make a decision formally about whether to approve or disapprove or reject this settlement. But what's important to consider is what happens if the settlement gets rejected? Well, the reality is that the parties can come right back with a new settlement that includes modifications, right? In other words, the judge could say, I see a lot of benefit in this, but I am concerned about this and this and that. So I'm not okay with this. I don't think it's fair, adequate, and reasonable to the class of copyright holders that are involved. But if you address these concerns, I might consider it, right? And there's questions of how long that would take, if it's practical or not. And I actually don't know whether it would be practical or not, or how practical. We can debate that. I'm not saying it would be easy. But I'm saying that things could get changed and a second version could come around for the settlement, right? Which is, again, different from what the product is doing and what the product could do. And then the other thing is that no settlement could be reached. It could be completely rejected. And then I think there's a question of, well, what happens to Google Book Search? Well, I mean, if we at least take the status quo, what happens is we go back to where we were, which is that the Authors Guild and the class lawyers and the publishers fight Google in court over a bunch of these issues. Now, I do think that what they're fighting over is a lot smaller than what the settlement offers in terms of the amount of access, right? So if you look at things like the out-of-print books, access to those and the 20% preview and a lot of these other issues, I mean, it's much bigger than what Google's doing now, and that's important. We can't forget that the settlement potentially offers greater access on a lot of levels, but it's not as if the whole thing goes away, right? I mean, well, it might if Google loses a lawsuit, but I can tell you my personal opinion, and most of the copyright scholars I know, is that Google has a very strong case. Yeah. So anyway, I'll just add that context that we should debate this also in terms of the alternatives. The judge will, in fact, only rule on whether this settlement is approved or not, but it doesn't mean in reality that that is an all or nothing.
And Jason, on that, because I think with the research corpus, which is this discussion, because the judge's question is approve or disapprove, not tinker with, it's approve or disapprove, as you point out. And if he rejects and then there isn't a resubmission, if we win the fair use case, which Google believes it would, there's still no research corpus. The universities could do some stuff, although I will say the universities have been fairly conservative about letting people access, because right now if they let someone have access to the books and then they go and do something else with them, they expose themselves to statutory damages, which can be very high. In other words, if they say, here, come do research on these 3 million books, and then someone takes 1 million of them and puts them on the web, their liability is very high. And so one of the benefits, one of the things we worked hard, because if the settlement were rejected, it's Google that holds access to, but we win the lawsuit. Google will have 20 million books to do non-consumptive research. Nobody else will.
Can I make 3 quick points in response to that? One is that, and I'll say this just on the other side, is that if Google wins a lawsuit and sets a precedent, that's a precedent others can rely upon. So that's one. 2, there are additional issues actually around whether or not, in fact, the statutory damages would apply to state universities. There are protections, the 11th Amendment of the U.S. Constitution, which maybe we'll talk about later about. These are very legal. But, I mean, in other words, there are arguments that, in fact, UC wouldn't be sued for damages and successfully.
Sovereign immunity can be lost.
Yeah. But the third one, though, and this is a question maybe you can address, is it's true that you can argue right now that if Google won, there wouldn't be a research corpus. But is it Google's position that they legally can't make a research corpus available?
Yeah.
If they win the lawsuit.
So in fact,
you think it would be a copyright viation?
No. So in fact, the issue is not, because we think non-consumptive. Now, I'm not a lawyer, but I actually spend a lot of time with lawyers. Clearly, if we
and you've held up well.
If we believe non-consumptive research is a fair use, then it doesn't matter whether that person's employed by Google or we let someone access to our database, to our servers, okay? I think me giving all the books to somebody for this, you know, whether or not that's okay, that's a question I don't know. The risk is, and we work with researchers today, it's just we have to be very careful, because certainly for Google, if I let Jim access my servers and Jim took 200,000 books, then Google almost certainly is liable for statutory damages if we let him access it and he did something bad with it. Okay, so we don't think non-consumptive research is a problem. It's just we certainly have this risk.
Right. We want to wrap up, but I want to get one more question.
Yeah, so I'm already holding the mic, so I'm going to go ahead and talk. I have a question. So bringing it back to the research corpus itself and the specifics of that. One of the points that Eric made that we haven't addressed yet is whether or not this provides a solid enough basis for ongoing scientific research, including the ability to, reproduce others' results. And I'm wondering what the settlement says in terms of, what does it actually mean to make the books available? I've seen a lot of full-text data sets made available in all sorts of ways, ranging from simply frequency counts of all the words that appear in books and articles, all the way to the whole shebang, including the images of each page and the outputs of any OCR that was done, the full outputs of the OCR, including the location of the words on those pages. How that data is made available makes a big difference to the kinds of research that can be done, and I'm wondering if there's any guidelines as to what that might look like.
Yeah. And one thing, for those of you that are, in fact, that question during the break, those of you that want to talk more about that, there's this question of how to build the research corpus, because the idea is there are two research centers, okay, and I'll tell you my view. My view is so first of all, you have full access is a simple answer in the research corpus. That, in fact, you're going to have the text, you're going to have the OCR coordinates, you're going to have the images, you're going to have everything. But the challenge is, how do you build this so that people can efficiently operate over them from computationally? And so we've done a lot of work. In fact, I would build it upon Hadoop. There's been a lot of work of kind of university data centers using things like MapReduce and Bigtable and other things, open source versions. And we've been very engaged in trying to communicate how we compute at scale. Okay, but think of each of the research centers as an open source community where people can be sharing code, accessing, building services. And I think there's a lot of interesting discussion about how to build an environment that allows both computer scientists and humanists access.
Great, thank you. I mean, one of the, is there one last pressing question, I think, from right there, and then I want to wrap up. Before we do so, I want to thank Dan for sort of jumping in, stepping in, because we were short of panelists. But yeah, one last question. Microphone.
I mean, I just think it's helpful to have more elaboration on the restrictions that the research institutions have of using the digital copies based on the contracts that they signed with Google. I mean, they can't really. I'm sorry, I'm Jamie Love. I'm with an NGO, Knowledge Ecology International. But if Dan could elaborate on what the research institutions agreed they would not have the freedom to do without the approval of either Google or the registry in terms of these services, because I think that's really at the core is how much freedom do they really have?
Yeah, and the simple answer is for non-commercial services, okay, they don't have to ask permission at all.
Well, when you say a non-commercial service, like say Berkeley wants to provide a non-commercial service, so you're saying that they don't have to settle anything. I mean, does that mean they can provide it for free for the public, for all academic researchers? I mean, people that don't work for universities, that do work for universities, they can take their own database and they can provide any service they want for free under the settlement.
Right.
And the only time the settlement would bind them is if they were either sued for copyright infringement by the right owners, or if they tried to charge money for it, and you said it violated the terms of their agreement with you.
Right. So there's the provision that says it can't be used to compete. you don't have to ask for permission. You do have a requirement to make sure it doesn't. I want to distinguish two things. One is you have to ask permission. So if you wanted to create a competing service to Google Book Search, okay,
Yes.
to take the index, then that would be prohibited.
Even in a non-commercial basis?
Even in a non-commercial basis, to offer a competing service to Google Book Search would be prohibited. Because it's taking, to take the algorithms, you can do whatever you want. But if you take the scans and the index you would build, you can't then build a competing service to Google Book Search. Would be an
Okay.
example. And Jamie, we can talk more during a break that I could explain.
It's clear to me that there's a lot more questions that need to be asked about this and a lot more discussion that needs to happen about this. However, I do want to say that we're out of time, and I want to thank the panelists, and I want to thank all of you for participating in the conversation. Thanks.